Each year, thousands of criminal cases are heard in courts around Australia. Here, some of the most serious crimes are heard before judge and jury. This is where justice is done. Now cameras have been allowed inside a district court.
But you're not sure whether you breached police procedure on this occasion or not, do you?
Why shouldn't Mr. Voris ask
There
about...
is simply no evidence.
Silence, stand.
On trial is Stephen Tofileo, 22, a labourer from Western Sydney. He stands accused of robbing and assaulting 72-year-old taxi driver Albert Franklin.
And then he said, "We want your wallet." And then I got a hit in the face.
The case is unusual, as the only evidence against Tofileo is DNA found on the pocket of the taxi driver's shirt. A cross-check linked it with Tofileo over a year later. A co-offender was never identified. Tofileo claims the DNA was planted by police to gain a conviction.
Then that DNA was definitely and certainly not deposited there in the way that the Crown allege.
Tofileo has already spent time in jail on remand. If found guilty on 4 counts, including robbery and assault, he could face 20 years behind bars.
Are you guilty or not guilty?
Not guilty.
H344054.
Defending the accused on legal aid is suburban solicitor Theo Voris.
My role is to really kick on behalf of the client, that is, fit in his shoes, fight for him.
The potential jurors who will judge his client are visually scrutinised before being impanelled.
You don't know anything about their background. You don't even know their names. They're literally numbers.
The prosecution and the defence can challenge the jury selection.
Challenge. You've only got 3 challenges, and ideally it would be good for probably a case like this to have as many young people as possible because of the DNA, because you're likely to get people to pay attention. Anyway, I think we're very lucky that they're mainly young.
In the public gallery is Tofileo's mother and younger brother.
Yes, then, Mr. Crown.
Thank you, Your Honour. Your Honour, before I start, would it be convenient for each of the jurors to have a copy of the indictment?
Presiding over the trial is Judge Helen Morell.
And is there a copy for me, Mr. Crown?
There will be a moment.
With scores of taxi drivers like Albert Franklin robbed and assaulted every year, Crown Prosecutor Mervyn Grogan presents the case against the accused.
We start just before 6 a.m. on the 25th of November, 2005. On that morning, Mr. Albert Franklin was driving his taxi along Elizabeth Street in the city. He got to the intersection of Elizabeth and Devonshire Street, and at that point, he saw 2 men running towards his taxi. The 2 men entered the taxi. One of them got into the front seat next to the driver, the other got into the back seat. The Crown case, and I'll say this right at the beginning, is that the person who got into the back seat of the taxi was in fact this accused.
The police identified Tofileo when they put the DNA profile found on the taxi driver's shirt into their system and got a hit.
A case like this with very, very solid DNA evidence, I think could be properly categorised as a strong case.
The defence case is simply that this accused, Stephen Tofileo, was not directly or indirectly involved in the robbery of Albert Franklin. Specifically, at no stage did the accused touch or otherwise hold on to the shirt pocket of Mr. Franklin. He was not present when Mr. Franklin was robbed. He says he didn't rob this taxi driver. Everyone's entitled to have their day in court. I take the presumption of innocence very seriously.
The victim, Albert Franklin, has been driving taxis for 20 years. He was heavily punched in the robbery and suffered serious facial injuries.
One of the problems we've got as cab drivers is that we drive along a street, someone puts their hand up and you pull up and you don't really know what you've got till you start speaking to them. And as soon as you start speaking to them, well, you can assess a person pretty quickly. And but obviously then it's too late. They're in the cab, so then you've got to make the best out of the situation that you're in. So you can feel very vulnerable.
Franklin is called to give evidence. On the day of the assault, he had just started his 6 a.m. shift.
The first thing I noticed was two chaps ran across from the right-hand side of the taxi. They ran, and one chap jumped in the front, another chap in the back of the cab and sat behind me.
Before they actually got into the taxi, what, if anything, could you see about their appearance?
They were a large build. They were running, they were in a hurry. They appeared to be psyched up,
Well, in terms of their appearance,
they were of vulnerable appearance.
what happened then?
They asked me to stop the cab. The chap in the front said, "We want your money." And I pulled the money out, which was about $100 in change because I just started work, and gave it to him. And then he said, "We want your wallet." So I gave him my wallet. And then he said, "Get out of the cab."
Why did you hand over your wallet?
Well, I didn't want to say no to any of their demands because,
Why not?
well, because I felt pretty threatened by this stage.
What's the next thing that you remember happening?
The other fellow that was sitting behind me, when I got out of the cab, he said, "Give me the coin." And I got the coin out of the money, the change out of my top pocket, gave it to him, and then he grabbed me by the pocket again.
Were you able to see or feel where his hand went relative to
Yeah,
your
it
pocket?
went right on my pocket.
Inside or outside?
It would have been, to my knowledge, outside.
And which pocket was that?
It was this left-hand side.
Can you just tell the court what were you wearing?
I was wearing an RSL taxi uniform with two pockets on the front.
What's the next thing that you remember happening?
The fellow that was in the back of the cab said, "Lay down on the road." And, well, I didn't really want to lay down the road. I thought I might get kicked or I might get run over. Or
What was it that happened after that?
well, I got a hit in the face, this part here.
And again, you're indicating the bony area just
that's
under
correct.
the left
There's
eye.
a fracture of the bone
Sorry, left eye, I should say.
and nerve damage to the face.
Did you see what the man who had hit you did? Where did he go?
He got into the front seat of the cab in the passenger seat.
What's the next thing that happened?
Well, I looked around and he backed up the road, and that was the last I saw of it.
Okay. Yes, thank you. Thank you.
The defence is keen to expose the lack of any other evidence proving Tofaleo was at the crime scene.
Whilst you're driving, you look in the rearview mirror, don't you?
No,
Don't?
because the guy in the front had my full attention.
All right. So is it your evidence that you
And
don't...
on top, sorry, I hadn't finished. On top of that, he was sitting right behind me, and it's extremely difficult to see someone in the rear vision mirror that's sitting right behind you.
The other opportunity you see the person in the back is when he gets out of the motor car, correct?
He which, sorry?
At the point in which he gets out of the motor car.
He gets out.
Yeah, he gets out of the cab.
Yep,
He gets out and you get out, correct?
that's correct.
He's standing near you, correct?
He's standing slightly behind me.
All right, but you have an opportunity to look at him at that stage, don't you?
Not at this stage, because the other guy in the front had my full attention. He was the one that was threatening me.
Well, can you tell us anything else about the person in the rear seat? Can you tell us anything about, for instance, what hair colour he had?
No,
The colour of his skin?
no,
The style of hair that he had?
no,
Whether he had glasses?
no.
All you can say about this man is that he was of a large build. Is that right?
Yes, the only time I saw the pair of them together was when they were running across towards the cab.
So the only description you can proffer about the man in the back seat, as you observed him, was that he was of a large build.
He was of island appearance. The chap in the front, yes.
You saw his skin colour, yeah?
Yes, well, he was of island and definitely island appearance.
But the other guy, the other gentleman, the other chap, as you want to describe him, you didn't see his skin colour, correct?
That's correct.
All right. You are very sure that the man that has got out of the back seat and approached you put his hand on the outside of your left shirt pocket. Is that so, sir?
You're asking me technicalities?
Well-
Now listen to me, you asked me a question, can I finish it? He grabbed me...
Of course.
Sorry?
Of course.
Right. He grabbed me on the shirt like that. He said, give me... I'd taken the coin out. He grabbed me on the shirt. Whether his finger went in, I don't know. But that was the exact movements.
The defence is trying to establish where exactly the DNA was deposited, on the inside or the outside of the pocket.
When you say grabbed, do you mean he pinched at it, or did he just place his hand?
Oh, look. I just told you heaps of times. He went like that. I gave him the coin. He went like that, right? I can't tell you any more.
And you agree that what you just demonstrated is consistent with a patting motion?
Yeah, I guess it could be.
Thank you, Your Honour.
Yes,
Mr.
thank you. You're free to
Franklin,
go.
be excused.
Am I? Good, thanks.
I think it's my first time in court, and hopefully the last, so yeah, I was nervous. Yeah. I would have liked to have said a lot more, but it would have been colourful language. They were obviously trying to pick holes in my story, and I was the guy that was there and I knew what happened, and so I was pretty adamant about telling the story the way it did happen, and it wasn't a very nice experience, and I wouldn't like it to happen again by any means. So, yeah, I was getting a little bit cranky at the end of it all.
I think the taxi driver's evidence at its highest is contained to, I mean, essentially he doesn't even see the skin colour of the assailant. If there was no DNA, this man wouldn't be on trial.
Theo Voris specialises in criminal defence.
We have a large Islander client base here. Most of our work comes through word of mouth. I think, technically, my practice certificate says solicitor and barrister, and that's what we are, but I'm not admitted to the bar. There are more of us without wigs doing trials these days than what there were years ago.
I'm not going to Wollongong anymore. That's been...
Working with Theo is solicitor Tennille Duffy.
So what do I need to do?
I think it's very important that accused people get every chance that the law provides to them, and that the Crown are really put in the position where they have to prove someone is guilty before anyone's liberty is even thought of being taken away from them.
On day 2, attention turns to the central evidence in the case, Tofaleo's DNA, and how to explain its presence on the taxi driver's pocket.
You've got to prove beyond reasonable doubt that the person that grabbed that shirt is the accused. The jury just has to be satisfied beyond reasonable doubt that the manner in which the DNA got on the shirt is in the way that the victim said it did.
The defence doesn't deny the DNA belongs to Stephen Tofaleo. What they question is how it got there. Theo Voris's job is to plant reasonable doubt in the mind of the jury.
If you isolate the evidence, all that can be said is it's probably his DNA on there. How it is that it got there, nobody knows for certain. And if there's a reasonable hypothesis consistent with innocence, this man should not be convicted.
What the jury doesn't know is that police already had a DNA swab of Tofaleo's saliva from another investigation for which he was acquitted. The defence will suggest the evidence could have been tampered with while in police custody. The police testimony today on how the evidence was collected and stored will be crucial.
The police evidence, which will essentially deal with the movement of relevant exhibits, swabs, the shirt, to the Division of Analytical Laboratories, and then we'll have the DNA expert come and give evidence about the results of her analysis. That could be challenged, I guess, in one of two ways. It could be suggested that there's been some sort of contamination.
Senior Constable Deborah Tanzer helped document Albert Franklin's injuries and collected his blue shirt as evidence.
Would you have a look at these 3 photographs, please? Are they photographs that Constable Moylan took?
Yes.
And is that a photograph of the shirt that you've spoken about in your evidence a moment ago?
Yes,
Once again taken by Constable Moylan?
correct.
Yes, I'll tend to those, Your Honour.
The defence must raise questions about the continuity of the evidence by suggesting that something happened to the shirt after it was placed in an evidence bag.
Those photos were taken of the shirt at the Marrickville Police Station, is that right?
Yes.
At 9:29 a.m, correct?
Correct.
You're aware that the shirt wasn't booked in as an exhibit and sealed until about 2:30 that afternoon.
It wasn't booked in until 2:30, but it was sealed after the photograph was taken.
It belonged in the exhibit room, didn't it?
It did.
But from 9:30 till 2:30, it wasn't in the exhibit room, was it?
No,
Where was it?
I don't recall where it was.
So anybody could have had access to that.
Well, I object to that. Your Honour, the witness is being asked to speculate about things.
Well, perhaps I'll ask it this way. Did you have access to the shirt,
Well, the shirt was in
which
the
was
bag.
in the bag?
I don't recall where I was, but the exhibit would have been in my presence.
When you say would have been, you mean ordinarily would have been, correct?
Yes.
But you're not sure whether you breached police procedure on this occasion or not, do you?
I'm not, no.
No. Thank you.
Senior Constable Catherine Hawes received the shirt from Tanser and stored it in the evidence room at Marrickville Police Station. It was there for 18 days until she took it to the police forensic laboratory for testing.
Is there such a thing as an exhibit sergeant or a person responsible for the entry and exit of that room?
When I'm on duty, or at the time when I was on duty, I was responsible for who was in the room and who gained access.
Yes, but when you're not on duty, is somebody else allocated that function?
The shift supervisor,
Is that someone usually of some seniority?
yes.
All right. And is it the case that he or she places the key somewhere that's accessible to all police officers?
Yes, the key is kept in a place where the sergeant would be aware if anyone picked up the key and took it.
But really, above all, it relies upon a trust system, doesn't it? That is the entry and exit of an exhibit room.
Yes.
So if you've got a dishonest police officer, then the whole thing breaks down, doesn't it?
It can.
Thank you, Honour.
Detective Senior Constable Williams describes for the jury how a buccal swab is taken to get DNA evidence.
The officer takes, it's like a lollipop stick that is a long plastic stick with a sponge on the end of it, places the lollipop stick inside each cheek of their mouth until it's sufficiently wet. The suspect's offered the opportunity to keep the lollipop stick, and if they choose to do so, they retain it. If they don't, it goes back in the bag. Once you take the sample, place all the items back in the sampling kit. There's a sticky part on the top of it that you seal together, and it's unable to be opened without ripping it.
Yes, the tamper-proof seal that you refer to is really, to open it, you do so by simply opening flap.
No, you can't actually open the flap. The only way to open the bag is to cut the bag open with scissors.
Or cut the seal open, you mean?
Or you could potentially cut the seal open, but it then won't re-stick.
No, but you can replace the seal on the bag.
No, you can't.
With a new one? No?
No, you can't replace the seal on the bag. You would need to get a new bag, which would have a separate number attached to it.
Thank you, Ellen.
The next witness is Detective Senior Constable Michael Lee.
We believe we had enough to charge him, and we did with the DNA evidence. Their job is to say that it was handled incorrectly, the exhibits were handled incorrectly. We're saying that we abide by the SOPs and therefore there's no cross-contamination.
Lee collected the DNA sample from Tofaleo while investigating him for another crime. Theo Voris is worried that if the jurors knew the circumstances under which the sample was taken, it may influence them.
He was under arrest and he was a suspect for committing certain offences.
But we can't agree to a proposition that a subsequent acquittal must mean that that's what came as a result of it. No wrongdoing on his part.
To say something...
Detective Lee is uncomfortable about giving evidence that may mislead the jury.
If you frame the question in those terms, well, look, Detective Lee, isn't it the case that he gave a buccal swab and that arose in a circumstance where there was no wrongdoing on his part? That's the concern you have, is it?
Yes.
That's the problem that I think exists. But there's no problem, as I understand it, and correct me if I've got this wrong, and the judge can say, and she's offered to say, look, that particular circumstance doesn't concern you. It's not a matter about which you should or can speculate, and then we just move on with the issues in the trial.
On the 10th of December 2005, you met with Stephen Toffelau, correct?
Yes.
You asked him to provide you with a buccal swab, correct?
Yes.
You told him that he was not obliged to do so, but he offered to do so, correct?
He consented, yes.
Well, I might just say at this juncture, members of the jury, that you've heard that all sorts of people may be asked to give buccal swabs, and you must not speculate about the circumstances that led police to request the buccal swab on this occasion. It's very important for the judge to ensure that there's no prejudice to the accused. For example, it would be most unfortunate if a jury became aware that an accused person had a prior criminal record, because that could be very prejudicial when they're deciding whether he committed the offence in question.
So you saw him being handed what's described as a lollipop stick with a sponge attachment to it?
Yes.
And he placed it inside his mouth and filled the sponge with saliva?
Yes.
It's sealed in a tamper-proof bag and taken to Marrickville Police Station?
Yes. It would have been stored in a fridge, which is in the exhibit room.
Yes.
At Marrickville Police Station.
So it follows, I'm asking you now, if I may, are you aware that the shirt of Albert Franklin was also stored at the same exhibit room in the Marrickville Police Station?
Was I aware of it?
Yes.
No.
You're aware now through sifting through all the documents and the brief?
Yes.
You've been a police officer for many years?
Yes.
You've seen exhibit bags on many, many occasions?
Yes.
So the process of breaking the seal and then resealing it is not a complex process, is it?
No.
You break it by cutting it open, the seal, and then just resealing it, is that right?
That's right.
How does the resealing take place?
It's placed around the bag,
Just
around the
another
edge of the
seal.
bag.
Another seal, another plastic sticky tape type of arrangement,
That's
is it?
correct.
Which any police officer in Marrickville Police Station as of December 2005 could get his or her hands on, correct?
Yes.
All right. Are you aware of any police officer accessing the Marrickville Police Station exhibit room, cutting the seal, getting access to the Mr. Franklin's shirt and then resealing it?
To my knowledge, no.
No.
As far as the tamper-proof bags are concerned, is there any way from your experience by looking at the bag to tell that it's in fact been opened and retaped?
Every time the seal is broken on the bag, and when the bag is sealed with the evidence tape, it is signed, dated, and it has the registered officer's number on it.
Yes, thank you. Thank you, Your Honour.
The defence has now raised the possibility that the DNA evidence has been planted. Will this create reasonable doubt in the mind of the jury?
You've got in the same police station Mr. Franklin's shirt from the 25th of November till about the 13th of December. The accused DNA is there on the 10th of December to the 15th of December. So there are 4 days that both the DNA of the accused and the shirt is in the police station, in tamper-proof bags, of course.
To dispel any doubts about its case, the Crown calls its pivotal witness senior forensic biologist Vivian Bilby.
If the evidence hinges on a DNA profile left at a scene, and the police do have a lot of suspects, we can exclude the people that weren't there. As far as, that's our main role, is to exclude people. If the profiles match, it's up to the court or the juries to decide whether the person is guilty or not.
The prosecution are now going to call their DNA expert. We will have our expert, Dr. McDonald, be present when that's done.
There tends to be a view that, you know, if you've got DNA evidence, you've got strong evidence. But what's becoming clearer and clearer is that the DNA evidence, really, to be valuable, has to be in context. And in a lot of cases, it may well not be in context, and there may well be perfectly good other explanations for the presence of someone's DNA at a particular spot without them necessarily being involved in the crime at all.
Vivian Bilby matched the DNA taken from Mr. Franklin's shirt to the accused.
The DNA recovered from the blue shirt, item 5, is a mixture that appears to originate from 2 individuals. Neither Albert Franklin nor Stephen Tofoleo can be excluded as contributors to this DNA.
Is it possible for you to identify the areas on the shirt that were examined? Now, as far as if we take the left-hand pocket, first of all, is that one of the areas that was examined?
Yes, both pockets were examined and combined.
Is it possible to see any markings on that left-hand pocket that indicates where the samples were taken from?
Yes, on the inside of the pocket, on the underside of the flap, and going down a little into the pocket, there's a white marking, and it was within this marked area that the sample was taken.
With these loose skin cells,
Yes.
could they get onto a surface through the process of somebody touching or grabbing hold of it?
Yes, generally a brief touch will not leave enough skin cells to be able to determine a profile. But with touching, grabbing, friction of maybe the hands, this is when skin cells come off and deposit themselves on the fabric.
Crucial to the defence case is a claim that the concentration of DNA found in the taxi driver's pocket was too high to have been deposited by hand contact.
DNA comes from different areas of the body, correct?
Yes.
Semen,
Yes.
that's a high yield source.
Yes.
That is, you'd expect to find a concentration of a greater amount of DNA from semen than relative to, for instance, skin cells through touching of an object. Is that a fair proposition to put to you?
That's correct.
So is saliva a richer source of DNA, is it not?
It's a rich source, yes.
The concentration of DNA which was detected on the blue shirt, I'm suggesting to you, is consistent only with emanating from a high yield source.
No, could be skin cells.
Skin cells from touching, is that what you're indicating?
It depends on individuals. Some individuals have a propensity to give up skin cells more readily than others.
Can I just ask you to consider this scenario in relation to the shirt? Somebody gets a mouth swab, a sponge soaked in someone's DNA, walks over to a shirt, the blue shirt, and goes swab, swab, swab. Inside, is that consistent?
Well, what we found was DNA, and we got a DNA profile from that DNA. Yes.
So the question is it consistent with what you found, yes or no?
Yes.
In relation to the testing of the shirt, are you aware of any reason why not the outside of the left and right pockets were not tape lifted?
No, the understanding was that something had been stolen from the pockets, and so that's why the inside of the pockets were targeted.
That understanding came through police, is that right?
That's right, yes.
I have no further questions. Thank you, Your Honour.
Mr Crown?
Thank you, Ron. Is it possible to definitively say what the actual source of a DNA sample is? Take saliva and skin cells shed from the hand, for example.
No, it's not, and also you have to bear in mind that the hand may have come into contact with a richer source of DNA. For example, if you rub your eye, the fluid around the eye is also a rich source of DNA. If you touch your nose, nasal secretions are quite a rich source. If you put your hand in your mouth for some reason, you may have saliva on it, and it's what has been termed as loading the hand.
Yes, thank you, Your Honour. Your Honour, that evidence concludes the Crown case.
Obviously, we were always going to be against the odds with this DNA, and I'll put it this way, I don't think it's gotten any worse than what I expected to go. I really don't know how it's going.
Day 3, and the defence prepares for court with their key witness. Molecular geneticist Dr. MacDonald will challenge the very basis of the prosecution's DNA evidence.
When you see a result like the one here, it tells me, or rings a bell for someone like me looking at it, saying, well, you know, the allegation of sort of hand or a grab is really inconsistent with this type of amount of DNA. So then you start asking yourself, well, what other sources of DNA could there be, or what other explanation is there?
The defence is banking that Dr. MacDonald's testimony will raise reasonable doubt in the minds of the jury about the source of the DNA found on the shirt.
What, in your opinion, is the likely source of the DNA which was tape lifted off the blue shirt, item 5?
Well, blood and semen, I think, are ruled out by, you know, examination of the item. So, you know, the only logical explanation of a readily available high-yield source is saliva.
If I can put this scenario to you in relation to the shirt, assume just for one moment the blue shirt is swabbed with a buccal swab.
Your Honour, I need to object, and there's an issue now that I'd need to deal with in the absence of the jury, I'm sorry.
All right, do you want the witness to be absent or not?
No, that doesn't concern me.
Well, the jury can be taken out.
Your Honour, this whole matter up until a moment ago had been conducted on the basis that my friend wanted into evidence, and I agreed to allow into evidence, the taking of a buccal sample from the accused on the 10th of December 2005. Then we progressed to the point at which the buccal sample, which resulted from that swab, was stored at Marrickville Police Station. Then, as I understand it from discussions today, the theory is that there is some relationship between the buccal sample stored at Marrickville and the shirt. It is a matter for which there is simply no evidence.
May I just ask you this, Mr. Voris? Are you leading this evidence because you're going in the direction that the swab stick could have been used to deposit the material which was inside the shirt? Is that the direction you're going?
No, I am, Your Honour, either the swab stick or any other sample associated with it.
So what do you want to put about the swab stick?
Along the lines of what was put to Miss Bilby, is it possible that the concentration of the DNA uplifted from the shirt is consistent with that scenario? And she answered yes, and I assume that'll be the answer from this witness.
Well, I mean, Mr. Crown, why shouldn't Mr. Voris ask that? I mean, he may be able to draw this together in some way, and anyway, I could give that answer myself. I know that the answer is probably yes.
The answer to that will be yes.
Yes.
No doubt.
So there's no harm done. We all know the answer anyway.
Well, I was actually trying not to waste time, but perhaps I have, so perhaps if we just move on.
I think I'll allow the question.
The defence can now continue to suggest its hypothesis for how the DNA got there, claiming it could not have come from skin cells alone.
You consider this for a moment, that on the 10th of December 2005, known as a buccal swab, which has been swabbed in the accused's mouth. And that swab is in the Marrickville Police Station. Someone opens the bag, takes it out, walks over to a bag which has the blue shirt and places the lollipop stick on the inside of the blue shirt. Yes. Is the DNA concentration and amount located on the blue shirt consistent with that scenario?
Yes.
Why?
Well, because the expected amount of DNA on a mouth swab is within the range that is found on the shirt.
Yes, thank you, Your Honour.
Yes, Mr. Crown.
Thank you, Your Honour. Your proposition is, as I understand it, and correct me if I'm wrong, that the amount of DNA is indicative of it having come from saliva.
Well, a high yield source of which saliva is the most likely.
Well, do you say it is saliva or something else could be the explanation?
Yeah, well, the predominant source,
Does that mean-
the high yield. I mean, it may well have some cells from skin or from hands included in it. But as what I'm saying is that from skin cells, the contribution to the total DNA, I would expect to be less.
Even if saliva might explain something of the DNA, it is still possible that the accused's skin cells explain the presence of DNA on the shirt.
Well, as I said, a minor component of it.
Well, but do you
would not
agree
be
with that or
excluded.
disagree?
Yeah, I can't do either. It would be...
Well, does that mean you agree or disagree?
No, if...
I object, Your Honour. Dr McDonald, in my respectful submission, was about to go on and answer, and the Crown Prosecutor again cut him off.
Well, no, I think the Crown Prosecutor was entitled to demand an answer to the question that was asked. Would you put the question again for my benefit, Mr. Crown?
Do you agree or disagree with the proposition that a possible explanation for the accused DNA being on the shirt is via skin cells from touching?
Not entirely, no.
Yes, thank you, Your Honour.
Well, you're excused. You're free to go. Thank you.
Thank you.
Mr. Virus and I have a disagreement about whether the hypothesis that he is advancing to the jury does in fact have some evidential foundation. There is an evidential foundation for the fact that on the same day at the same police station, one source of DNA was present and a shirt was present upon which the Crown case is there was already DNA. But there is no evidence beyond that. There is no evidence that anybody accessed that material, put it onto the shirt, and that somehow that was able to be done without anyone at the DAL noticing there'd been an alteration to the bag, no one noticing there was an alteration to the shirt bag, no one at the police station in authority noticing any of these things either.
With no more witnesses, the Crown Prosecutor commences his closing argument.
You do not have any evidence whatsoever to support the proposition that that swab made any contact with the shirt. Evidence is evidence. Inferences can be drawn, but they have to be drawn from evidence. And I suggest to you that when you look at the evidence and when you consider this DNA issue, you'll come to one conclusion. The only person I'd suggest to you that could have touched that pocket in a way that left DNA was the person who committed the crime, the backseat passenger.
It's now the last chance for the defence to create doubt in the mind of the jury. Can they be certain Tofoleo is guilty of assaulting and robbing the taxi driver?
This prosecution, you may well think, has the hallmarks of a near enough is good enough prosecution. Because on the one hand, what's drummed into you is beyond reasonable doubt, burden of proof, high standard. And on the other hand, you've got to, well, look, Mr. Franklin didn't really say the hands went in. He didn't say the hands went at all, as far as he's concerned. To the best of my knowledge, were his words, it was on the outside. But let's forget about that, because that's near enough. We'll just say that what he really meant was inside. The near enough is good enough. Prosecution continues in not only that aspect of the evidence, but because Albert Franklin was able to identify the man in the front as being an islander. That's good enough. We just assume that the second guy was an islander, even though Albert Franklin really said, when pressed and cross-examined, look, I didn't see skin. I don't know what colour his skin was. But near enough is good enough. If one's an islander, the other one's probably an islander. The defence submits to you that if you look at all the evidence in its entirety, you would have a reasonable doubt that it was indeed Stephen Toffolo that robbed and otherwise injured and assaulted this taxi driver. And the only appropriate verdicts the defence says you could return in those circumstances would be those of not guilty. Thank you, ladies and gentlemen. Thank you.
Judge Morell gives final instructions to the jury.
In this trial, the accused has decided that he won't give evidence. The prosecution bears the onus of proving the accused's guilt beyond reasonable doubt. The accused does not have to prove anything. He is presumed to be innocent unless and until the prosecution proves him guilty beyond reasonable doubt. Therefore, you cannot treat the accused's silence as an admission of guilt or as filling in any gaps in the prosecution case. What the judge's job is to explain the law, the relevant law, to the jury. So the jury has to accept the law as the judge gives it to them. The jury has to determine the facts entirely from their own observations of the witnesses, from the evidence, and just using their common sense. The critical issue is, are you satisfied beyond reasonable doubt that the accused's DNA got onto Mr. Franklin's shirt when the rear seat passenger touched or grabbed Mr. Franklin's pocket? Then it follows that you'd be satisfied beyond reasonable doubt that the rear seat passenger was the accused. On the other hand, if you considered that the hypothesis put by the accused, the hypothesis concerning the shirt and the swab being at the police station at the same time, if you consider that that hypothesis is a reasonable hypothesis, not that it's true, but that it's a reasonable hypothesis, then it would, I think, follow that you would have a reasonable doubt about how the DNA got there and therefore whether the accused was the rear seat passenger. Very well, members of the jury, I now ask you to retire and consider your verdicts.
The jury must determine Stephen Toffolo's guilt or innocence on 4 charges: robbery, malicious wounding, assault, and stealing a motor vehicle. If found guilty, he could face up to 20 years jail.
When it all comes out in the wash, I think we did a good job of putting across what our argument is to the jury, and I think that they were paying attention, and I think that they were listening carefully to the evidence, and I think that they'll consider it carefully. But yeah, it's just waiting now. It's the hardest part sometimes.
At 4 p.m, the court is reconvened.
They've been out for, getting on for 2.5 hours, and I suspect that means they've been out for nearly 2.5 hours.
Silence, all stand.
Just as she is about to adjourn the court for the night, Judge Morell receives a note from the jury.
The jury has reached a unanimous verdict.
Have you agreed upon your verdicts?
Yes, we have.
Is the accused guilty or not guilty of count 1, robbery in company?
Guilty.
Is the accused guilty or not guilty of count 2, maliciously inflict grievous bodily harm?
Not guilty.
Is the accused guilty or not guilty of count 3, assault occasioning actual bodily harm?
Guilty.
Is the accused guilty or not guilty of count 4, steal motor vehicle?
Guilty.
Thank you very much, members of the jury. This was an interesting trial in more ways than one. Thank you very much for your time and attention. You are now discharged.
Very disappointed. But yeah, look, it was always going to be a hard trial, there's no doubt about it. And yeah, I mean, DNA.
The verdict has been returned. That was the jury's conclusion, having assessed the evidence. End of the day, move on to the next case. Okay.
3 months later, the court reconvenes for sentencing.
Judgment day, he's getting sentenced. He's getting sentenced in respect of 2 matters, the trial matter and another matter. So I don't know how, I don't know what the judge intends to do in respect of both of them.
Tofaleo is also being sentenced for another offence for which he pleaded guilty.
Your Honour, I seek to tender a psychological report under the head.
Did you want to call any oral evidence or not?
No,
No. All right. There are no victim impact statements, I take it, Mr. Crowe?
I was just going to raise that with Your Honour. Mr. Franklin is here, and I would be asking Your Honour to receive and consider his statement
Yes.
at the time.
Well, perhaps I'll do that before I read your submissions, Mr. Voris.
Thank you, Your Honour.
I thank the court for the opportunity to put my feelings across today. Every time we taxi drivers pick up passengers from the street, there is an element of danger attached. In my particular case, for a period of time after the incident, I was nervous picking people up. I decided I had to drop this attitude as it was making it difficult for me to do my job efficiently. So, other than my facial numbness and my drooping eye, there are no serious ongoing effects from this experience. Thank you.
Yes, thank you very much, Mr.
Thank you.
Franklin. You may return to your seat. Thank you.
Thank you, Your Honour.
Mr. Voris, I suppose since I've read your written submissions, did you want to address me about the objective seriousness of the offences?
He has realised that the root of his evil, if I can put it in those terms, is his alcohol and drug dependence. And the only point that I seek to make is that the first step in addressing a difficulty is accepting that you have it. And I think the point that I seek to make is that this offender now accepts that.
Yes.
And indicates an intention.
Mr. Crown, do you accept that there's been remorse?
No, I don't, Your Honour.
You don't? Okay.
I'm not out to see
Right, thanks,
people punished. I just tend more to feel a bit sorry for them, even though I was a bit knocked around, so...
Judge Morell will shortly hand down her sentence.
Yeah, I just wish it was finalised, you know. I'd like it finalised, but it's another, you know, still dangling there, so when it's finalised, I feel better.
Silence, all stand.
Sentencing is quite a stressful part of any judge's function. It's a very subjective and intuitive exercise. There is no right sentence. The best sentence, I suppose, is one that both parties can live with and neither is happy with. The author of the pre-sentence report notes the offender's entire criminal history seems to be related to alcohol and or drug abuse. The offender gave evidence, which I accept, that he has an almost complete lack of memory in relation to the incident because he was so affected by alcohol or drugs. In sentencing the offender, I consider that there are special circumstances, they being the offender's youth, the fact that he has not previously served a sentence of imprisonment, the need for there to be a long period of support in relation to drug and alcohol and emotional issues when the offender does re-enter the community, and the total picture of his incarceration. Would you please stand? Mr. Tofaleo, you are convicted of each of these matters. You are sentenced to a non-parole period of 3.5 years and a total sentence of 6 years. You are eligible for release to parole on the 11th of November 2010. Thank you. I'll adjourn.
Silence, all stand.
The sentence was, in our view, certainly a reasonable sentence. The conviction for the robbery I still feel uncomfortable about because it's entirely open to say that if it was two non-big islander males, the starting point probably wouldn't have been robbery. I mean, I can't say. But I mean, we'll think about it. Perhaps two scrawny-looking businessmen walk in and say, "We want your money." The taxi driver probably would have laughed. Would that have been a robbery? I don't know.